Hello, this is Eric D. Smith with a graphical approach to law, and this is a summary diagram of damages available for breach of contract. And so the damages you can see are divided here. Damages that are available at law and damages that are available in equity. So these two columns are the main tracks, the principal one of which is going to be, of course, damages available at law. And the types of damages that are principally recovered and are looked at for recovery first are the ones that are shown in the biggest text and in the bold text. So the first types of damages that a court will look to are damages at law for breach of contract, and the main block of them here is going to be shown in the bold rectangle that bears the number 1. So these types of damages at law are the ones that are first looked at as remedies. So number 1 is expectation damages. These are what value or what profit was expected to be made if there had not been breach of contract. This is the standard measure of recovery, and the first type of damages that are looked at as a remedy. The second type of damages are consequential damages. The principal characteristic here is that these consequential damages need to have been foreseeable by the party breaching the contract, and they are a second category different from expectation damages, and hence fourth, the dashed line here shows a differentiation between expectation damages and consequential damages. A third type of damages is incidental damages. These are minor damages that arise because of the breach of contract, so they are of a lesser sort. Nonetheless, they are included here in the main block of types of damages principally looked at for recovery. So at law, the court will look to provide, if appropriate, first of all, expectation damages, secondly, consequential damages, and thirdly and lesserly, incidental damages. That is the block shown here with the number 1. Now, other types of damages available at law are nominal or declaratory damages, perhaps a recovery for $1. This is certainly of a lesser and nominal, minuscule sort. So they are shown here for the table to be complete, but this type of damages are relatively of minor consequence. Now, the most severe type of damages would be punitive damages. However, punitive damages are not available at law for breach of contract. Punitive damages are not available, so for this reason, cross-hatched area is shown here, showing that this type of damages is not recoverable, not allowed, not given by courts for breach of contract. The types of damages we covered here, expectation damages, consequential damages, and incidental damages, are types of compensatory compensation for damages. That's why this dashed block is shown here. Now, other types of damages at law are damage amounts stipulated in the contract, otherwise known as liquidated damages. These are estimates of damages specifically written into the contract, and these are available if such are written into the contract and such are deemed appropriate by a court at law. The UCC, under the Uniform Commercial Code, there will be a comparison between the liquidated damages that are estimated and the actual damages suffered. And if the estimated damages or liquidated damages are appropriate, those will be awarded. Now, things that can lessen the damages recoverable are, for example, if a person went to the market and mitigated their losses or otherwise sought to go to the market and obtain the goods that were not provided by the contractual obligations, and so forth, if there was a type of self-remedy someone looked to and actually obtained savings in the marketplace, then the savings or profit made, so to speak, by looking to someone else other than the defendant who has breached the contract, if actual savings were achieved, then that can negate all damages because the plaintiff actually came out ahead in monetary terms, in total monetary terms. So if savings were obtained, that will negate either part or all of the damages at law. Also, of course, the plaintiff has the duty to mitigate, and so failure to mitigate will also result in similar consequences, in that failure to mitigate will lessen the amount of damages recoverable. So the first type of damages looked at to be recovered are damages available at law, the three types of which were covered here and under the block labeled number 1. Now, secondarily, the court will look to apply equitable relief, and the first type of equitable relief here will be in block number 2, reliance damages. These are damages caused because of the reliance of the plaintiff on the representations of the defendant. These are associated with promissory estoppel and the unjust enrichment of the plaintiff. So the first type of damages in equity to be looked at will be reliance damages, number 2. And then in block number 3, the court will look to restore the plaintiff to the position they would have been in if there had not been breach of contract. So that is block number 3, restitution damages. These are damages in equity, so we have to look at factors such as the unjust enrichment of the defendant. There can also be the remedy of a constructive trust, and this runs the spectrum of the court's consideration in equity of anything from rescission of the contract going all the way to reformation and a type of rewriting of the contract only done in equity. Also recoverable in equity is specific performance. This is a more severe type of remedy because it actually requires the defendant to specifically perform on the contract. This would be done with an injunction by the court. However, this is only done if there is an item of unique item whose value is uncertain, so the unique item itself has to be provided. One example of that is a land sale contract where all plots of land are deemed to be unique. So the main track to follow with a contracts fact pattern with breach of contract is block number 1, then proceeding to block number 2 and block number 3. Now, of course, these damages, these remedies are provided at different times and in different circumstances. So, for example, if we look at the stages of a contract, there's stage 1 formation, stage 2 the executory stage, and stage 3 the breach of contract or the completion of the contract. In general, these are the types of legal remedies available here. Legal remedies at the formation stage would involve either real defenses or personal defenses to the formation of the contract. Once the contract is executory or in effect, then the law of conditions or a careful examination of the conditions supplied in the contract are going to be looked at for legal remedies. Once there is breach of contract, then the standard money damages are looked at. So, for example, under compensatory damages are going to be expectation and consequential damages, as well as incidental damages and declaratory relief. Under equity, in the formation stage, usually no remedies are applied. However, in the executory stage, restitution is the principal remedy, running the spectrum from rescission to reformation. And under the breach of contract stage, the reliance damages are applied sometimes with injunction and specific performance.